The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15 here in the Des Moines area and the surrounding area of Des Moines, the town surrounding here. You can watch our program at 1 o'clock on Sunday afternoon and Wednesday evening at 9:30. You can also watch the program in Council Bluffs on Cox Channel 23. It's aired out there every other Thursday at 4:30 p.m. You can email us at vocaliowa@mchsi.com. And we appreciate taking phone calls from parents out there that are struggling with DHS on losing their children or on abuse reports that DHS may have written up against you. My number is 515 here in Des Moines, 276-3956. And John's number in Des Moines is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report, Child Protection in Iowa. We want to make a few remarks in this program to indicate some of the directions that we intend to go, and those are twofold. Number one, we like to let people know that we're in business to influence public policy as it relates to child protection issues. Some of those issues also happen in courts, and so we've invited, for the last many months, Terrance Walker to join and contribute some of his insight with respect to what is needed in the courts to support that general principle of child protection issues. Because without a cooperative court, we're not going to have the kind of society that we strive for, the kind of society that our country was built around, unless those courts are shaped up. And he has this kind of notion that maybe the courts ought to get shaped up. Either that or those fellows that sit behind the bench leave their posts and leave it to somebody who knows something about the Constitution, who knows something about the rule of law. In addition to influencing public policy, it is our intention in Vocal to work with individuals who are having difficulties with the Department of Human Services, some say Department of Inhuman Services, and to watch what is going on there. Well, we do go to council meetings. We do watch what's going on in the Department of Human Services, and we answer the phones many times in desperate situations. We're not attorneys, so we don't hold ourselves out to offering legal services. In fact, it's very difficult to find a good attorney at the price that a lot of the people that we deal with can afford. But we do offer to give you assistance to the extent that we can, some hints that may be helpful to you, whether you are operating with an attorney or without an attorney. So there's the format of, as far as our prospects are concerned, the way we view the world from the Vocal standpoint. A lot of things have been happening in the news, and we're going to gather up a lot of articles that are occurring even right now. In the judiciary, for an example, there's an article in which a judge has determined that it is his place to determine whether and how children will have their sex education um, dispensed to them. It is not up to parents. Well, sorry about that, Judge, but you need to find another job. And it probably should be far outside of the judicial system, because you don't belong in the judicial system if you're going to interfere with parental rights. Another case that we saw, and Don can read that case to us in just a moment here, and that is a Missouri case in which a judge brought forth a favorable decision. Don, can you tell us about that favorable decision in the state of Missouri, where they have backed off of the child abuse registry, calling it unconstitutional? Don?
A Missouri Circuit Court judge ruled Thursday that the state's child abuse registry is unconstitutional because it does not allow alleged abusers a due process hearing before being placed on the list. What they're talking about there is parents, like you and I. You never know when you're going to be put on the child abuse registry, and that's what goes on in Iowa. Without your knowledge, you can be put on this registry, and then after a while, it comes back to haunt you, and you didn't even know what happened to you in the first place, even though the law says they're supposed to notify you, but they don't always do it. As a result, one way you know that you get on the registry is all of a sudden you go to work and your boss says, you no longer have a job here. I just found out you're on the child abuse registry. You say, I am? I didn't know that. What did I do wrong? Oh, well, I can't tell you that. That's confidential. Anyway, all those kind of stories and the words confidentiality that DHS loves to hide behind. Anyway, this article goes on to say, the registry is not available to the general public, but child care facilities and other employees can use the list to screen current and potential employees. Judge Richard Callahan said the current process caused damage to suspected offenders' reputations and careers. He used the word suspected. They haven't even been brought into a court of law to be found guilty of any crime. There's an old saying in the United States, innocent until proven guilty. But not with our good DHS. They just love to smear your reputation, whether you're guilty or innocent. Let's find out if you're guilty before you start getting your reputation smeared. It goes on here. The judge also said that the hearings must use a, quote, preponderance of the evidence standard rather than probable cause, which has already been changed by a 2004 law. So last year, the legislature finally got smart and changed a few words in the law to help people out there that are falsely accused. The Missouri Department of Social Services said, now that's the same as we have here in Iowa, the DHS, but they have Department of Social Services in Missouri, said it is considering appealing the decision to the Missouri Supreme Court. And Judge Callahan's ruling will not go into effect until the appeal process is complete. So what the judge just did in his ruling is null and void until the Supreme Court confirms or rejects this judge's ruling. Now, the Department of Social Services, it says here, is going to appeal the decision. I hope it's the same thing as what we heard Assistant Attorney General Mary Kay Wickman say a couple of years ago, that she fought a case, it was a DHS case, and I don't know what the ruling was in district court, but she decided to appeal that case to the Supreme Court, and she lost big time, all for the benefit of parents. She lost, but yet her desire, based on her paycheck, is to destroy families. Well, that's my opinion. John, it's your turn.
The registry is a real problematic situation at best. And now, having been revealed for what it is, that is one which does not give anyone due process rights, which means proper notice and your day in court and a full-scale appeal process and the ability to summon witnesses before a trier of fact. That isn't the way they do business at the Department of Human Services or at the Department of Inspections and Appeals. It isn't even the way they do business in district court when it goes in for judicial review. They just play games with this, and it is destroying a lot of people whose careers have been built up, and because they get an adult abuse report against them for one reason or another, because someone died on their shift, then that can kick them out of a career path completely, simply because they're listed on upon the adult abuse registry. And what's listed on the adult abuse registry also concerns people who are hiring individuals or employees in daycare work or in other occupations that have to do with children. Without that due process and without the ability to resist the reports, then these goofy social workers can write up anything they want about anybody they wish, and for some reason it is hallowed as though it were fact. Well, Don, you've fought for a number of years with the authorities on child abuse reports that were totally incorrect, and found that you didn't get all that kind of support from the Office of the Attorney General, from the administration of the Department of Human Services, found a little assistance in the Office of the Governor, but that certainly wasn't long-lasting. And certainly wasn't comprehensive, was it? You've run into some problems even now that you've gone 15 or 18 years away from your original report. Why don't you tell us what you encountered, Don, as you try to resist reports? Try to straighten things up on their records. They don't want things, apparently they don't want things straightened up. They want to play games, and I think it's a sad arrangement. Would you tell us a little bit about that? Maybe you got a suggestion about what they should do, Don?
Oh, yes. You mentioned that in my case, starting back the DHS legal issue started back in 1985. Anybody with it's any good with arithmetic can figure out how many years I've been fighting this case and how long DHS been resisting based on lies and how they can get by with doing this on lies. Now, John mentioned that I got a little benefit from the governor's office. I'm not sure what year that was. That was well over 10 years ago that they gave me some information. And I got some paperwork here. Just give you a general idea. And within it is some paperwork. It came from the governor's office. Attachment 1, Attachment 2. But anyway, thanks to the governor's office, I got a couple pages. Not much information, but there was just a little bit of detailed information that the DHS had been saying didn't exist, didn't happen. And lo and behold, I find out there's a whole nother file out there that DHS covers up. Anyway, that's just a side issue that I just attached those papers back into the Supreme Court again. Uh, it just doesn't seem to make any difference how much truth you pump into the court system. They just listen to the DHS lies and keep right on going.
Do you think that's because they want to rule on behalf of the governmental body? I'm just being devil's advocate here. What is your opinion on that, Don?
Repeat that question again.
Do you think it's because they tend to lean towards the view of the governmental body? Is there some sort of pressure there, you think?
For the judges, are you referring to the judges?
Yes.
Camaraderie.
To rule in the DHS favor. Well, I don't know. They're all tied together to the state. They all feed out of the same trough to get their paycheck. And if they rule favorably for Don, which occasionally I get some favorable rulings, some very good rulings, but if they do too much, then it could cost the state of Iowa a lot of money. Other parents could gain from this information, and it would be devastating on the state of Iowa. But in order to be really devastating, we got to stomp on the individual workers' toes to get their attention. They're out to destroy families, and if the citizens of Iowa listening to this program don't pay much attention to what we're saying on this program, and then a year later they get a knock at the door from DHS, I suppose we could say, well, we told you so, you just didn't listen. I mean, we've been telling facts for years here, 9 years, I'm guessing, on this program. And the system just keeps destroying families. I'm going to put in front of John's camera here, and I want him to zero in just so you can see that I'm quoting from the Supreme Court here. And if you notice that it's a motion to dismiss, and you can swing over to the other side, John, and you can see my name on there versus DHS. Okay, I'm going to take it off, John. And I'm going to quote you a little bit out of this document. I got to take it off so I can read it. Comes now the DHS, and for the following reasons, moves to dismiss this matter. This was an appeal to the Supreme Court I just did recently. And so the Attorney General's office, which is Attorney Phillips in this case, filed a motion right away to stop me from going on into the Supreme Court. See, he's got to do this. This is one of the powerful tactics he's got, because once it gets into the Supreme Court and the judge hears the evidence and makes a ruling, there's a fairly good chance that they might rule in my favor. And then the Attorney General would lose. So this is a tool that he uses to try to stop this from action from getting in front of the judge. And he says, the appeal denoted by the heading set forth above is ultimately an attempt to appeal agency action under Chapter 17A of the Iowa Code. 2. Specifically, appellant seeks to appeal a decision of the Polk County District Court denying judicial review of that action. That's true. I came out of the district court, and you have a right to appeal the action, the ruling that the judge did. I'm going to skip on down through here to get to the point that I was wanting to bring out on this program. Number 5. Additionally, appellant has failed to timely file his notice of appeal. Now he's telling this to the Supreme Court, trying to get Don removed through this motion to dismiss. You can't see it there very well, but what I showed you earlier, motion to dismiss. So he's saying that Don has failed to timely file his notice of appeal. The order from which appeal is sought was issued on May 16, 2005, and appellant seeks to appeal pursuant to a notice of appeal filed on or about September 23, 2005. May to September. Well, what he's basing this on is the law that says you have to appeal a district court decision within 30 days. Well, anybody can figure that's well over 30 days from May to September. How come it took so long for Don to get to that point, or to that date? Well, there's been a lot of things go under the bridge, so to speak, since that point in time. So you file in the Supreme Court based on a final decision. You don't file before the day you're born or whatever. You can't do nothing until after you're born, or different reasons. But they come up with all kinds of excuses to try to stop you. John can't figure out why I threw in the you can't do anything before you're born. Well, I would think that'd be understandable because you're not an adult yet. You can't think on these lines, just like the judge can't think along these lines, or the DHS. Anyway, it goes on. However, such motions which were denied did not toll the time for appeal. The second and third motions were filed more than 10 days after the ruling in question and were themselves untimely. I'm going to...
So he said that one of them was filed about 4 months after an issue, and then the other one was filed within 10 days. So I don't understand which one is late. Which one? How is that one untimely? The second one.
let's see if I can find... Okay. Nope, that's the wrong one. Well, I was hoping I would have that laid right out here. I had the judge's ruling that you start your action on. Yeah, you get so many papers going into the courts, it's so easy to lose the...
I
get
think I
mixed
can
up on the
comment on that a
paperwork.
little bit, though. If it's within 30 days, it should be timely, right?
I got it here. Okay. All right. Put that on the camera, John. Zero right in there and swing it down to the judge's...
Stay with your mic.
Zero into July, dated, that's close enough, dated 25th day of July 2005. Down below at an angle, it's signed Judge Rosenberg.
July 25th, right?
That's correct. Now, I'm going to change pages here.
Denying the motion for new trial.
Motion for expansion of ruling.
And new trial.
It's pretty faint. August 1st. See the 1 right over my fingernail. August, AUG 1. And that's the filing stamp, and down here is the Attorney General. I got it in the next day. See, that's August 2nd. Well, anyway, that's 7 days. And that was in district court. That he tried to throw me out, stop my paperwork based on the fact that the law says you have 10 days to file a motion in the district court. And I did it within 7 days, and he said I went well beyond it. I go into the Supreme Court now, just recently, and he brings it back up again, saying that I filed untimely. What do you need, John? And so I filed a whole bunch of paperwork there, and I took the liberty of pointing out some more errors that the attorneys have been doing.
So what? I was trying to figure out when. So you filed the appeal after that to the Supreme Court? After the August 2nd?
Yes, correct. Well, it was actually 3 months. He's saying to the Supreme Court that you have to do it within 30 days. Well, you see, I filed motions later, and then the
Yeah.
judge made more rulings.
Yeah. Well, you
And
can file. Yeah, you can file it after. You got to file it after everything's been resolved. Typically,
final decision.
final decision. You got to file the motion for new trials and all that stuff
You,
too.
you can't file before the judge's
Yeah.
final
Because
decision.
I tell you what they do is if you file the appeal and then file a motion for a new trial, a lot of times what they'll say, and I've dealt with the state attorneys myself, they're wily. Yeah, you know that character Wile E. Coyote from the Looney Tunes? They're very wily, tricky. So no matter what you do, they're going to claim that it was some sort of technical error. I don't care if you file it within 10 days, after 10 days, within 30 days, if the rule says 30 days, or after 30 days. They're going to say some sort of technical error. But so you filed it within 30 days after that to the Supreme Court, and then they still said that your appeal was late?
Well, he's basing it on the district court issue where he said I did it past the 10-day rule. And I just pointed out to you the filing stamps proved that I did it within 7 days. It was
Yeah.
on the 7th day that I filed with the district court. So he's going back to then, trying to pull the rug out from under me in the Supreme Court. So how long is he going to continue to lie, and the courts are going to overlook his lie? I mean, I have my rights too. You can't throw me out on a lie. Well, you can.
Well, these are the games they play.
You're right. Now, I'll go here. I followed up with a resistance to motion to dismiss. See my name over at the other side, Donnie Burgmaier. And this was filed October 21st. And then I'm going to go on down here, John, and you can catch a little bit here. It comes now the appellant in his resistance to motion to dismiss, and you want to widen it out a little bit. Right there, I want to read that. That's a common law. Right there's a common law word, raise. I can't read Latin. Can you, Terrance? Anyway, it means the facts speak for themselves, unquote. The issue should not have to be explained beyond the obvious facts. Well, then I went on down, and I'm just going to jump down here where Judge Brown made a ruling back in 1987 on my case. There hasn't been any sexual abuse. Okay, then we'll go on down to line 4. Well, I will go on to say that Mary Kay Wickman is continuing to throw me out of court, and I was found innocent clear back in 1987. Down into line 4. It is well established by the Iowa Court of Appeals, Burgmaier was not even given due process notice. The DHS broke their own rules. The Iowa Court of Appeals reversed and remanded the sex abuse case on January 25th, 1990. Okay, I'm going to change pages. It says, next page, the Iowa Court of Appeals ordered that Burgmaier has a right to a hearing. That's interesting. Parents have right to hearings. Let's see. I want to jump over at this point in time. I'm going to jump past Mary Kay Wickman's lies and over to Judge Phillips.
That's a lot of jumping.
You got it right. We've been jumping for 15 years, and the courts cover her up, protect her. Now, Judge Phillips, who took over the case, I think because Mary Kay Wickman got in hot water over the lies she's been presenting here, so then Phillips took over the case, Attorney Phillips from the Attorney General's office, where our tax-paying money goes in to give them a job. On August 4th, 2005, Counsel Charles K. Phillips, attorney for the DHS, responded The court, let's see, responded the rules of civil procedure do not contemplate multiple post-trial motions. And then I go on with my document. The court never ruled that plaintiff has not properly invoked this court's jurisdiction. In this case, he tried to throw me out in district court because the court hadn't invoked jurisdiction. Jurisdiction is an important word in the court system. And then I talked about where Phillips talked about me filing in an untimely fashion, not within 10 days. And I said Burgmaier responded on August 1st, 2005, within 7 calendar days from the court's ruling of July 25th. And I put attachments in. I showed you the filing dates, that made it within 7 days, not 10 days, not 10 days, not 12 days, which would have made it illegal for me to file at that point. Counsel Phillips responded to appellant's motion based on the hand-delivered copy that was timely delivered to his office. Got a file stamp on it. How can he sit there and lie when he got a paper with the file stamp right on it showing 7? If he can calculate, I guess he can't do arithmetic. I don't know what school he went to. The Attorney General's copy has the clerk of court filed date dated August 1st, plainly stamped on that copy. It's in red. If Phillips can read Burgmaier's copy, he can read the file stamp. He read it good enough that he could file another document and return, try to throw me out of court. I asked the court to admonish DHS counsel to learn how to count. Here I quoted Montgomery versus Iowa Department of Human Services. Quote, "We have recognized this legislation was intended to provide greater opportunity for persons accused of child abuse to correct any adverse findings." And then I'll go on here to my conclusion. The file stamps prove counsel for DHS is attempting to mislead and to perpetrate fraud on the courts. The court must admonish DHS counsel Phillips to learn how to count. Mary Kay Wickman is continuing to deceive the court by refusing to retract the statement. In this case, she quoted Lynn Burgmaier's never asked for expungement. Well, that goes into a different issue that I don't have time to talk about today, but I would enjoy proving that she lied about that back in 1991, where she made that statement to ALJ Wampler, Administrative Judge Wampler, in her argument. Wickman made those statements to the ALJ and repeatedly to the district court and repeatedly to the Supreme Court. That statement is the reason for Burgmaier, that's me, being in the Supreme Court 14 years after she originally made the statement to the ALJ Wampler. This is quite a game they got going on, and I haven't quit the fight. The court must admonish Mary Kay Wickman. Burgmaier stands on all paperwork filed. I just provide the truth back to him. Okay, I want to finalize with what happened to me when I filed these papers at the Supreme Court a few days ago, and then I took a copy over to the Attorney General's office, which is required by law, so I met that requirement. I went in, came to the desk where I've done it many, many times to get papers filed, and I waited for assistance. A man comes over. I wasn't quite sure at that time who he was, and he said, "Mr. Burgmaier." He knew my name. And he said, "May I help you?" I said, "I need somebody that knows how to run that machine that file stamps." And he said, "Well, I can take care of your papers here." So he reached under the table. He didn't even go over to the file stamp machine. Keep that in mind. He brought out a stamp, and he stamped the papers. See, let's just put that right on the camera, John. We'll show the Supreme Court file stamp at the top. It's in red. I just stamped it a few minutes before I went to the Attorney General's office. Then then this man, this kind-hearted man, stamps this here paper. And if you notice, it talks about the date at the top, but there's no date written in. Polk County Deputy Sheriff, Deputy U.S. Marshal. What's that got to do with the Attorney General's office? There's no information written in the lines. That's what he stamped, my paper, and he stamped the paper I left with the for the Attorney General's file. And so I walked out of there thinking about what he did. And I talked to John Harvey here that's running the cameras with me. And then I walked back in to the same spot I was there at the desk. And the secretary that usually helps me, she come walking over. And she said, "May I help you, Mr. Burgmaier?" And I said, "Yes, look at this paper." John, you want to swing back over to that again? Right there. "I don't understand that. I just brought this paper in here to get it file stamped. What does that mean?" And she went down, started describing to me, telling me what that is. She said that maybe a sheriff will come in or a deputy sheriff into their office there, and they will have a subpoena for one of the attorneys there or somebody, secretary or whatever. And so they have this stamp to stamp that subpoena, and then they fill in the date there, and they write down the little bit of information below and the AG's number. See, they don't even have it on my paper. And what division it was delivered to. You know, they filled out that. "That's what that's for," she said. Well, I said, "That doesn't show that I ever filed this paper or delivered a copy to you." And I said, "I would appreciate it if you would file stamp." And so she did. She went to the machine and pushed it in there, and it stamped it in there, November 4th. And so she did what I asked her to do. And then I said, "Well, the paper I left with this office, it was done the same way. There's no proof that I delivered one to this office. Would you see if you can find that paper and file stamp that while I'm still here?" And she spun around on her heel. Well, I'm not sure exactly what she did, but I don't know if she really wanted to do it. And then she walked over to her desk. She knew where it was all the time. That guy that had done it previously, he had dropped it off at her desk to take care of after that, to file it. And so she brings it back and she file stamps it just like my copy that I showed you. And so now it's file stamped. But you see, if I wouldn't have come back and got a proper stamp on that, Attorney Phillips could have went into the Supreme Court and said, "Mr. Burgmaier never provided a copy to this office." Now I got the proof that he did that Mr. Burgmaier did it, me. Now, why do I know this can happen? Because they pulled that stunt on me before, but I have the file stamps. I always get file stamps. Remember that. Anybody that works pro se, always get a file stamp on your paperwork so that they can't deliberately lie in court and try to trick you and win the case. And so before I left, I said, "Who is that man that helped me on this case?" John, you remember his name?
Gordy Allen's name?
Was it? That's right, John. Attorney Gordy Allen. He's on the tax roll. I mean, not the tax roll. He is paid to represent the DHS. He's an assistant attorney general, and he did that. He knows Mr. Burgmaier. I told you he said, "Mr. Burgmaier, may I help you?" That was nice of him. But I do not appreciate the deceit that is going on out of that Attorney General's office at taxpayer expense. At that point, John, I'll turn it over to you. I got more to say if you run out of time in this program.
Okay. We're going to be following a story from Dickinson County. This isn't the first time we follow stories from Dickinson County because that's where Shelby Dewis lived her life out. where she was killed at a very tender age. In Dickinson County, in fact, in the state, they said we can't avoid some of the problems that we have in child abuse because we just don't have the time and the money to do it correctly. Well, let's find out what happens in Dickinson County when we follow an auditor's report that indicated that one of the ladies in Dickinson County decided to abscond with taxpayers' money. Buying a car, buying personal things, racking up all kinds of credit card bills at Walmart, paying her mother $36,000, in excess of $36,000, for writing a grant, for doing all kinds of things at taxpayers' expense at a time when DHS is telling the legislature they don't have enough funds. I think that it's come time, long since, that we need a full-scale house cleaning. On the 2nd of November, her trial is set. We don't know what the date is set for her fraud trial, but we do know that that the judge set hearing on this lady's fraud trial, and I would imagine that they will attempt to get all of that delayed until after the DHS has had an opportunity to go to the legislature and ask for big bucks. Keep in mind, this occurred way back in 2001, and they've had all kinds of time to sweep things under the rug. It was about that era in which we lost that little girl, Shelby Dewis, because they said they didn't have enough workers. They didn't have enough workers. They had more workers than they've ever had in the history of the Department of Human Services. 2,005 workers rated as social worker 3s to do child abuse reports. They didn't pay attention. They weren't watching their cue cards. They weren't doing the job that they were hired to do, and that is to protect children. And now we find that they had their hands in the till besides, and spending money on personal things from taxpayers' money. Taxpayers don't like that, and taxpayers should not approve of that kind of business in Dickinson County or anywhere else in Iowa. I think it comes time when we need to get on our high horse. We need to get out that broom and sweep these offices clean. Then lock them up. It's time that we improve services and not permit people running around like this saying, we're doing such a good job, we're doing what's in the welfare of the children, and we overlook the fact that we are getting our funds stolen right out from under our eyes. Maybe you have a comment or two about the judiciary and how it's tolerated this kind of nonsense in the past, Terrance, and just exactly where the judiciary sits on protecting people's rights, citizens' rights. Terrance Walker.
Thanks for having me on the show again, John and Don. I'm the self-appointed, or you could say God-appointed, judge of the judges here, because nobody else can do it better, obviously. Nobody else has stepped up to the plate, and there's surely no office for this type of dialogue or discussion. You won't see this anywhere because we think in this society, or at least our officials do, that judges are above the law. And that has led to a lot of problems in this society, which is why there is such a furor, public furor, the past couple of years over what's going on and what's taking place within the judiciary. Judges rewriting laws, judges ignoring the facts, judges manufacturing facts to justify their rulings, and judges outright changing the law or otherwise ignoring the law in favor of their personal opinions, biases, or prejudices. We see this time and time again One organization has actually done something about it. There's a lot of legal reform organizations that are attacking the problem of the judiciary and trying to rein in judges in some shape, form, or fashion. One organization has created an organization called Judicial Accountability Initiative Law, has taken a big, giant leap in getting something done in this problem. And this article comes from South Dakota because this is where they actually have their first step that has taken place. An article by Chet Brokaw from the Associated Press dated November 7th in the Aberdeen News. That's aberdeennews.com if you want to look it up online. In Pierre, South Dakota, a South Dakota businessman has turned in about 46,800 signatures supporting a ballot measure that would let people sue judges they believe have abused their authority. William Stegmaier of T, South Dakota, on Monday gave the petitions to Secretary of State Chris Nelson and State Election Supervisor Key Warney. If Nelson's office says the petitions have the required 33,456 valid signatures, the proposed constitutional amendment will go to a statewide vote in the November 2006 election. The measure would strip judges of their traditional immunity from lawsuits related to their judicial acts. People could seek damages or criminal charges against judges they believe have harmed them by deliberately violating the law. Stegmaier, who owns a business that makes livestock feed grinders, said judges should be held accountable if they engage in misconduct. Right now, he says, quote, I'm quoting, for all practical purposes, judges enjoy judicial immunity. Even if they do something wrong, it's virtually impossible to hold them to account. Opponents contend the measure is not needed because state circuit judges' errors can be corrected by normal appeals to the South Dakota Supreme Court, and if judges are guilty of misconduct, they can be voted out of office or disciplined by state judicial qualifications commissions, opponents argue. Opponents also say the measure could lead to problems because the special grand jury would handle complaints against judges, could ignore the law or apply it differently in different cases. Well, isn't that the pot calling the kettle black? Those are my comments. Stegmaier said the Judicial Qualifications Commission is not effective because it is tied too closely to the legal profession. Most people do not know how to contact that commission. Judges should be held accountable when they act outside the law or their jurisdiction, Stegmaier said. And he says, I'm sure most complaints will be thrown out. Stegmaier said judges sometimes abuse their authority by preventing people from offering key evidence in trials. Judges should allow people to argue that even though something may be a technical violation of law, it would be wrong to apply that law in the case. Stegmaier said he has not personally been hurt by judicial misconduct, but he became interested in the proposal after seeing some abuses by judges. The proposed amendment is based on a similar measure in California, but never made it on that state's ballot. It would eliminate judges' immunity in cases involving deliberate violations of the law, due process, or constitutional provisions, and would take away judges' immunity for any deliberate disregard of material facts, acts outside their jurisdiction, or the blocking of a lawful conclusion of a case. People could file complaints against judges after the traditional appeals process has concluded. A special statewide grand jury would handle complaints, deciding whether a judge could be sued or face criminal charges. The grand jury would be drawn from the statewide list of registered voters and from non-voters who submit their names to the pool. Lawyers, judges, and law enforcement personnel could not serve on the special panel. That's a good idea. If the grand jury found probable cause of criminal conduct by a judge, it could indict the judge and create a special trial jury that would act as both judge and jury, deciding guilt and any sentence. That jury could judge both laws and facts, a departure from normal courtroom procedure in which a judge decides questions of law and a jury decides questions of fact. The measure would apply only to South Dakota state judges. Petitions were turned in last week for another constitutional amendment, and the rest of this stuff does not pertain to this. But I think that it's very interesting. I think that it's a big milestone that the organization of jail has passed here with the first uh, referendum, so to speak. Is that what it's called, a referendum?
Referendum
Where
state.
you get
Uh-huh.
a certain amount of signatures that's required and basically have a vote, statewide vote. I think that's a huge milestone, and I think that we're walking in the right direction. And you know, those are some really interesting arguments. We've actually went over some of those things that were discussed by the opponents of the legislature before on this show several times. One is that a lot of opponents of reforms typically say, as this article correctly relays, that the Judicial Qualifications Commission, they can discipline the judges. Well, we've seen time and time again that that's a fallacy. They typically only act if a judge has somehow done something against another judge or the judiciary, so to speak. And then they put up the argument against the legislation again by saying that judges can be voted out of office. Judges can be voted out of office here in the state of Iowa, too. But how often is that done? Now, my organization, Vote Iowa Judges Out, we also advocate voting judges out in the state of Iowa, which we do have every right to do, and I think that 90% of the judges, and I do think that I'm talking about all the state judges, because we can't vote out federal judges, unfortunately, but I think that all the state judges, with the exception of David Wiggins and who's the one on the Court of Appeals,
Rosemary Sackett. Uh-huh.
Those are the two that I think we should probably keep in office in the Court of Appeals and the state Supreme Court, because I have seen that their opinions do somehow ring with some sort of wisdom to them, and they do not capitulate to the powers that be and to the governmental bodies or to the big businessman or to the big, what should I say, the big special interest groups or anything like that. Their rulings try to bring some sort of balance to things. Now, as far as the rest of the judges, I really can't say too much for. They've, time and time again, cases that I've examined have capitulated to the powers that be, the governmental bodies, and they've more or less trampled on any individual rights that we have as citizens. And I see that day to day, and I look at a lot of cases. But some other complaints. Did you have some comment on that, John? Because I know you were talking about how they misconstrue facts.
They certainly do.
They take liberty with facts.
They certainly do, and I think I'm going to have a case before the commission one of these days. But I have some good, solid evidence to show to the commission. The commission doesn't always operate, though, real well. You have a case about that, don't you?
Yeah, we had the results of the case. We had been talking about the past couple months an incident which transpired out in Adel at the Adel High School, whereby Frank Brown and Del Lawrence had, on behalf of FIJA, Fully Informed Jury Association, had been passing out leaflets distributing the information on the role of jurors, as well as an article that was from the Cedar Rapids Gazette talking about the penalty for a burglary case. And this was outside the Adel Middle High School, where they had temporary court because the Adel courthouse is falling apart. So they had the pre-trial hearing, I guess, before the jury was impaneled.
It was jury selection.
Jury selection in the matter of Pierre Pierce, or is it Pierre Pierce?
Yeah, right.
Former Iowa Hawkeye basketball player.
Correct.
Now sentenced in jail. But anyway, he was initially charged with burglary, and Dell thought it would be a good idea to go out and try to get some information out to the jurors so they didn't unknowingly sentence this guy to 25 years. Well, they don't sentence him, but they would pass the guilty or not guilty verdict. And but this article that was on the back of the flyer, informational flyer of FIJA, which displayed on the front the informational materials concerning, or informational facts concerning jurors' roles, and then on the back they had the article from the Gazette. But the judge came out and basically accosted these individuals who were exercising their First Amendment right to distribute leaflets and pass information along. And he basically threatened them with 6 months jail or a $500 fine.
Or both.
Or both. For doing this, and told them they had to leave or they had to stop doing it or else. And he said, mark my word. Was that his words? He
Yeah.
said, believe me. He said
Believe
something
me,
to that
believe
effect.
me.
And,
I'll have you thrown in jail. Believe
Judge
me.
Gregory
Believe
Holst,
me.
I call him No Pulse Holst, because in his mind, the idea of justice is dead. Because we have a free society, or we're supposed to, and information is supposed to flow freely. You know, whenever you have somebody that in an official role is trying to thwart that, when this is information out of the Cedar Rapids Gazette. The information is out of our constitutional rights, which is on the front of the flyer. But he felt it his duty to come out and take jurisdiction over the sidewalk, as John Harvey aptly pointed out in his complaint against the judge, or Del Lawrence had pointed out, and didn't do anything. I mean, the Judicial Qualifications Commission, who this complaint and the videotape of the whole incident was sent to, didn't do anything. They basically sent Del Lawrence and Frank Brown a form letter stating that the commission is authorized by the Constitution of established in 1975, and it provides blah, 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 and it oversees violations of the canons of judicial ethics. And I think you guys pointed out in the complaint which canons you were thinking about. Well, this commission says they completely reviewed the complaint and finds that there's insufficient evidence of judicial misconduct, and they dismiss the complaint. Now, everybody that has sent a complaint to the Judicial Commission that I know of, me personally, has gotten the same letter, different name, same letter. Now, I would think if they were doing some sort of analyzing of these complaints, you would find some sort of details explaining why they arrived at their conclusion, but we don't know that. But that's why we need to implement voting Iowa judges out and some of the other measures, I think, by jail. But that's my 2 cents. I think we got to wrap it up because it is time to go.
And here's a couple of numbers that may be good for reference, and we'll see you next